Good afternoon, and welcome to our webinar today titled The Demise of DOMA, What It Means for Married Same-Sex Couples and Their Families. I am HRC's Director of Estate Planning, and I have the absolute privilege of helping HRC members and the LGBT community at large better understand the importance of proper estate planning and assisting HRC members in creating planned gifts to HRC through their estate plans. As you know, since the Supreme Court's historic ruling in U.S. v. Windsor striking down key parts of the Federal Defense of Marriage Act, several federal agencies have issued rulings or guidance on how those agencies will implement the DOMA ruling with respect to important federal benefits, protections, and programs now available to married same-sex couples. And we want to make sure that you are fully informed with all of the important information so that you can take the appropriate steps to protect yourself and your family. And it's my pleasure to have with us today Robin Merrill. Robin is HRC's Legislative Director for Administrative Advocacy, and her work focuses on federal programs and administrative policies that impact the LGBT community. Robin will begin our presentation this afternoon by providing us with an overview of the Supreme Court's DOMA ruling and the recent federal agency pronouncements. And then I will focus on why it is now important for all same-sex couples to review their existing estate plans as a result of the DOMA ruling. Robin, I will now turn it over to you.
Great. Thanks, Adam. And thank you so much for thinking of doing this webinar. It's definitely an important issue, and it's definitely also not very intuitive to a lot of people what these decisions mean to them, how their benefits will be impacted, and what steps they need to take to make sure that their families are protected. So as you can see on this first slide, there were actually two Supreme Court cases that took place this summer. Hollingsworth v. Perry focused primarily on California's Proposition 8, so we will not be covering Hollingsworth v. Perry today. Today's webinar will focus exclusively on the United States v. Windsor, which struck down the Defense of Marriage Act. And in this case, Edie Windsor and her partner had married in Canada, and they lived in New York State. And when her partner passed away, although they were married, the IRS did not recognize them, which meant that Edie Windsor was handed a over $300,000 inheritance tax bill. So she took this to court and successfully won in United States v. Windsor. And so what the United States v. Windsor had done is basically say that the federal government may recognize same-sex couples. Before, the Defense of Marriage Act required the federal government to only recognize married couples that it consisted of a man and a woman. And so by striking down DOMA, Windsor doesn't necessarily create new benefits, but instead allows the federal government much more room to recognize same-sex couples that are recognized in the states that they live in, which is really in line with how the federal government has recognized marriages since the beginning of the country. So you'll see on this slide, and I promise not to read all of the slides to you, but I feel like this quote really encompasses the power of this decision and how the court really viewed DOMA. So this provides, DOMA instructs all federal officials, and indeed all persons with whom same-sex couples interact, including their own children, that their marriage is less than worthy than the marriages of others. The federal statute is invalid, for no legitimate purpose overcomes the purposes and effect to disparage and to injure those whom the state, by its marriage laws, sought to protect in personhood and dignity. Now, what I want to really draw your attention to here is the words of the choice of the state to recognize and state marriage laws. So you'll see on this map, it becomes a question of which state do you live in, and does your state recognize your marriage? Now, we've divided this up into two different standards, and these standards are how the federal government recognizes your marriage. This is either done by a state of celebration, meaning the federal benefit or program looks to the state where you married to see if you're legally married, or to the state of domicile. And that means that even if you were in a state that recognized your marriage, but you moved to a state that doesn't recognize your marriage, then you were not recognized. And each agency has their own sort of approach to this. Most use state of domicile or state of celebration, but there's not a consistent federal approach across the agencies here. So you'll see here we have our Perry plaintiffs making a guest appearance on our Windsor webinar, and so say that they live in California and marry in California. Now, as long as they stay in California, they are eligible for all federal benefits available to married couples because they're living in a state that recognizes, so that's their state of domicile. But then also they were married in a state that recognizes, so they're also in their state of celebration. So what happens if they move? So if they move to, say, South Dakota that has no marriage recognition, then they will only keep the federal benefits that are based on a state of celebration model. And as we'll discuss, this is going to include immigration benefits, this is going to include IRS and tax filing status. However, this is not likely to include Social Security or a few other key benefits. So say that they move to another state that recognizes their marriage, that status stays the same if they move to, for example, New York or Massachusetts. Maryland, until this last election, would recognize marriages that were performed out of state, although they would not recognize their own, they would not perform the marriages. So that's the case in several states. So if that's the case in your state, then you would be in a similar position of being eligible for all federal benefits. So with that sort of background, we're going to go ahead and launch into the different really headline benefits and issues that people are very concerned with. So the first is going to be immigration. Now, the DHS, U.S. Department of Homeland Security, has adopted a place of celebration rule. And I think it's really important to point out that, you know, in this webinar, and we might often say they've adopted, but really this standard has been in place by the administration and by the agencies since the regulations were written, sometimes going back to the 1950s and 60s. So I think maybe it's more accurate to say immigration uses a place of celebration rule. And this makes sense looking at foreign marriages. So if you've been married in Canada or Spain or other places that recognize your marriage, and you come to the United States, DHS recognizes your marriage. So applying the same standard to same-sex couples in the United States, if you are married in California, regardless of where you live, you're a same-sex couple, then DHS will recognize your marriage for all immigration purposes. And this is really a huge benefit and life-changing for so many people. It's going to provide equal access to spousal visas for married binational same-sex couples, which is huge and allows you to sponsor your spouse for the first time. Marriages will also be recognized in U.S. embassies for all visa purposes. So immigration benefits are one of those benefits that if you are impacted in a huge way. So we encourage you to look through the DHS website. They have some great resources there, and to use those benefits if you're eligible and married. Next, we are moving on to the military. Military and the Department of Defense have also adopted a place of celebration rule. And what makes this actually interesting is that the military is recognizing that although a place of celebration rule is definitely more accessible to a lot of people than the strict state of domicile rule, there are still some, barriers to getting married in a place of celebration. If you, for example, live in Texas, and the closest marriage state is, in fact, Iowa. So what the military is doing is providing 10 days of extra leave to service members who need to travel to a marriage equality state. And this really provides folks with the extra cushion they need to be able to apply for a marriage license, go through the waiting period, and get married in a state that may be 11 or 13 hours away from their house. So what these military benefits are going to do, they are going to allow equal access to spousal benefits, and this includes ID cards, military health coverage, and housing allowances, among other benefits. Obviously, this is huge. It's a huge step forward for same-sex couples. Although, if you've been watching the news at all, you'll see that some states are still putting in some hurdles for National Guard members. We are working on this, and we are very hopeful that this will be resolved soon. There's not much of a basis when the Secretary of Defense tells you to implement a policy and you don't. So, however, if you are a same-sex couple and one of you works for the National Guard, just note that that is a flagged issue and hopefully will be resolved very soon for you. So moving on to federal employee benefits, this is another interesting benefit because it impacts workers really nationwide regardless of where you live. OPM, the Office of Personnel Management, has adopted a state of celebration rule. Similar to the other rules, it means that if you get married in Massachusetts but you live in Texas, then you can still be eligible for your federal employee benefits. And what these provide for spouses are health care coverage, dental, vision, retirement, and workers' compensation, among other federal employee benefits. And these benefits are also now available for children of federal employees and a federal employee's same-sex spouse. I would also flag here that as of last summer, the Office of Personnel Management put out a public rule expanding benefits for children of federal employees' domestic partners as well. So there, in a lot of places, you may not have to be married in order to put the child that you are raising on your FEHB plan. So this is another great example. For example, if you work in the VA in Oklahoma City, regardless of where you live, as long as you were married legally in a state that recognizes you, you can receive your federal employee benefits. So moving on to sort of a meaty issue that I know that Adam is going to get into quite a bit is IRS and tax issues. And this is something that is going to affect every single same-sex couple across the nation. So what the IRS has done, they've also adopted a place of celebration rule, which means that if you are legally married anywhere, you should plan to file your taxes as married filing single or married filing jointly. But the IRS will view you as a married couple regardless of where you live. Now, what this is going to provide is equal access to spousal tax treatment, pooling of income, including filing status and access to exemptions. Now, you have an ability to file as married, which will potentially reduce your household tax burden, but I would say that it may reduce your household tax burden. Married filing jointly or separately might also raise your tax burden. So as Adam, I'm sure, will advise, it's best to check with your tax advisor. You can actually amend, going back 3 years, your tax return if you've been married, for example, in Massachusetts or Washington, D.C. for the past 3 years, and amending would be beneficial to you. You can go ahead and amend, but again, we suggest checking in with a tax advisor to make sure that that is going to be the best outcome for you. Also very important is going to be an end on taxation on employer-provided health coverage for same-sex spouses. And a lot of companies that had been grossing up, meaning providing additional income to spouses who put their same-sex spouse on their health insurance, a lot of those companies may be stopping that process. So we're stopping that additional piece of income. So do check with your employer to see if anything is changing with your health care coverage for your same-sex spouse, just to make sure that everyone is on the same page about that. Another huge issue, and this is the issue that came up for E.E. Windsor, is the spousal exemption for tax on gifts and inheritance. And this is really a huge benefit for spouses, and it really recognizes the shared life and the shared income that people have together. You know, as we saw with Edie Windsor, she actually just inherited some property and things that widows inherit, and was walloped with a $370,000 bill. So this is going to be huge and life-changing for a huge amount of people. So as we covered, you're going to have to file as married, either separately or jointly. Now, I would flag that non-marriage states will almost certainly not recognize your marriage for state income tax purposes. So a lot of states also have a state law that requires you to use the same filing status for your state return that you use in your federal return. So this obviously is tricky because you just can't do that legally. So a lot of the state revenue departments are issuing guidance. We encourage you to look online for that guidance. HRC will also be publishing material on different states' tax issues for you. So hopefully there will be plenty of information out there. It is most likely that you will either have to file one federal return as a married couple and 2 separate state returns. Some states are having some more complicated income splitting issues. So again, check out that guidance that should be online. Talk to your tax advisor or a volunteer tax clinic to see how the best way for you to go forward. So as we covered, if you're amending your return, just be sure to check with your tax advisor to make sure that's the best plan for you. So being recognized for federal tax purposes may increase your tax liability, limit the use of certain tax benefits, and like the head of household filing status, as well as the adoption tax credit. That will go away because the adoption tax credit, you cannot use an adoption tax credit for adopting the child of a spouse. Same-sex spouses may now fund a spousal IRA for a non-working spouse. Also huge in the retirement world is that 401k plans are now required to recognize same-sex spouses. This will allow a surviving spouse to roll their spouse's IRA into their own. This will avoid a lot of unnecessary inheritance and allow sort of the natural flow of marriage and the death of a spouse to happen. So same-sex spouses can also not be cut out of their spouse's 401k plan without their permission. So if you have your 401k plan and you have already, you've designated someone who's not your spouse, if you've designated a family member or friend to be your 401k beneficiaries, that your spouse now can't be cut out. So if you would like that to still be the case, you just need to get your spouse to provide permission for that. Next, we're going to look at employee benefits. And this is a good example of sort of the federal government adopting a few different standards just based on regulations, when the regulations were adopted, and what they do. So the Department of Labor adopted a place of celebration rule for protections under the Employee Retirement and Income Security Act, or ERISA, as you probably are more familiar with, and all related laws. And as I mentioned, spousal protections under 401k and traditional pension plans will also be recognizing based on a place of celebration. Also very key, same-sex spouses now have a right to continue health care coverage under COBRA. So if you lose your job and your spouse was originally covered under your health care, they can actually continue to be served by your plan for the entire extent of COBRA. I would mention that FMLA currently uses a place of residence rule for determining eligibility for benefits to take that leave. This is, as I mentioned, one of those existing regulations that has been in place since FMLA passed in 1993. So an existing regulation will have to change. However, that is the only change that will have to take place. This isn't a statutory issue. So just for consistency's sake and increased access to these crucial benefits, we're hopeful and optimistic that in the future that you will be eligible for FMLA leave regardless of where you live, but that's definitely one of those stay tuned issues. And next we are going to look at veterans benefits. The VA has issued guidance recognizing same-sex marriages for home guarantees, spousal health care benefits, and survivor benefits. Now, I do have to say that these benefits are currently only available to couples who either lived in a state where the marriage was recognized at the time of the marriage. So if you lived in Massachusetts and married in California, then that would work. However, if you lived in Texas, traveled to Massachusetts to get married, and then went back to Texas, that would not work. People who are also living in a state that recognizes the marriage, and this is the traditional state of domicile model, you will also be recognized. So it's sort of a mix of state of domicile and sort of state of celebration or past domicile. A statutory change may be necessary to expand access to benefits for all same-sex couples. HRC is diligently working with the administration and coalition groups to try to solidify this for you. Right now, I just have to say that only those two categories of marriages will be recognized for VA benefits. And finally, one of the biggest topics that is concerning to people is Social Security. And the Social Security Administration is now processing some retirement spousal claims and issuing benefits for same-sex spouses. Again, due to a statutory restriction, Social Security is only recognizing spouses who live in states currently recognizing their marriage. Although we believe that there is room for a broader interpretation, we are still waiting on future guidance for same-sex spouses living in states that do not recognize their marriage. We're also waiting on information on eligibility for individuals in civil unions and domestic partnerships. We believe that if you are in a civil union or domestic partnership and inherit as a spouse under the law of your state, then you should be recognized for Social Security purposes based on the law. And what Social Security has done is they've been very aggressive with trying to get people to apply for benefits if they believe that they're eligible. And what this does is it preserves your claim. Because even if you're denied a claim wrongly, they go back and they look at when you originally filed your claim. And you can actually get retroactive benefits that way. Otherwise, you cannot get retroactive benefits. So what we've been encouraging folks to do in Social Security is if you believe you're possibly eligible, if you live in a state that recognizes your marriage, if you're in a civil union or domestic partnership, go ahead and apply and start that ball rolling. We also get quite a few questions on what happens if you move after you start receiving Social Security based on your spouse's work record. Right now, the Social Security system actually just doesn't have the administrative procedures in place to cut off benefits. It's just not what they do. They don't end people's benefits. So we are fairly confident to say that, for example, if you live in Iowa and start receiving benefits from your spouse's record in Iowa as a same-sex spouse that is recognized, and then move across the border to Nebraska, we believe that you should retain your benefits. However, there is a caveat of this is definitely a new territory for everyone, and it is unclear whether the Social Security Administration will be aggressive in cutting people's benefits off. Again, we're just waiting on future guidance, and we encourage you to contact either the Social Security Administration or your local LGBT group, or actually us at HRC if you have questions about Social Security, about when to file, etc. So with that, I'm actually going to turn it over to Adam, who's going to inform you about estate planning.
Thank you so much, Robin. What is estate planning? Estate planning involves putting in place legal instructions specifying your own wishes for how your property and medical care will be managed during your lifetime if you should be unable to act for yourself due to disability, and how you want your estate to be administered and your property to be distributed after your death. And I really see estate planning as an opportunity. It allows you to proactively put in place a plan to protect yourself, your property, your loved ones, and it allows you to support causes that you believe in through planned giving. An estate plan is particularly important for the LGBT community since most core issues of estate planning are matters of state and not federal law. Not planning means letting your state do your own planning for you according to its own rigid rules. If you don't have a plan in place, then state law will determine how or who will have the authority to make fundamental medical, legal, and financial decisions on your behalf if you should be unable to make those for yourself. And state law will determine how your estate will be administered and to whom your property will be distributed after your death. While marriage equality and relationship recognition is advancing rapidly across the country, as you can see from the map that Robin showed earlier in the presentation, many states do not provide any legal protections for same-sex couples and their families. So relying on your state's default estate plan for you can really lead to results that are misguided at best and tragic at worst. The state may make decisions with no recognition of your spouse or partner. So a key point to really take away today is that while overturning DOMA was obviously a major victory for the LGBT community, it definitely does not reduce the need for comprehensive estate planning. In fact, in light of the DOMA ruling, we are urging all same-sex married couples to work with their attorney and advisors to review their existing estate plans. So for members of the LGBT community, it is even more important to treat these estate planning matters formally without relying on your state's default rules. I want to just briefly go over the essential estate planning documents that each person should have in place. They include a last will and testament, which allows you to set forth your wishes for care of your loved ones and distribution of your assets after your death. Up-to-date beneficiary designations for all retirement accounts, life insurance policies, and annuities. Please note that these assets will pass at your death outside the terms of your will, so it's very important that your current beneficiary designations reflect your wishes. A financial power of attorney, which allows you to name a trusted person to act on your behalf in all financial matters if you are unable to act for yourself due to incapacity or if you're unavailable. A living will, which allows you to specify your own wishes for life-sustaining treatment in the event that you are unconscious and have no reasonable chance of recovery. A healthcare power of attorney, which allows you to name a person to make medical decisions on your behalf if you are unable to make those decisions for yourself. And a HIPAA release authorization, which is a document that specifies who may have access to your protected health information. And HIPAA stands for the Health Insurance Portability and Accountability Act, which is a federal privacy law. Be sure to find a lawyer that you are comfortable working with and who is familiar with the planning issues facing the LGBT community in order to work with you to develop your estate plan. Your attorney may recommend additional estate plan documents based upon your individual circumstances as well, but be certain that you have these essential estate planning documents in place. As Robin mentioned, the DOMA ruling has a direct impact on employer-sponsored retirement plans. Most employer-sponsored retirement plans, including pension plans and 401k plans, are governed by a federal law known as ERISA. And ERISA provides that if you are considered married by the federal government and are eligible for a pension or other employer-sponsored retirement plan, the plan must meet specific requirements. For example, under ERISA, your spouse must be given written consent if you wish to name anyone else as your beneficiary for your retirement plan. And so we are urging all married same-sex couples with employer-sponsored retirement plans to immediately review their beneficiary designations and benefit elections to make sure that they are up-to-date, accurate, and complete, and obviously reflect your current wishes. And please do take the time to review this information. Waiting may hurt you and your family with respect to these very important benefits. Also, the DOMA ruling has a direct impact on federal gift and estate tax planning for married same-sex couples. As you're probably aware, the federal government imposes gift and estate taxes. And one main goal of estate planning is planning to minimize or limit gift and estate taxes through very careful planning. After DOMA, the tax planning incorporated into your current estate plan may no longer be applicable. And this is because the unlimited marital deduction, which allows you to transfer an unlimited amount of property to your spouse during your lifetime or after your death without any federal gift or estate tax, is now available to married same-sex couples. So federal gift and estate tax planning has in a way become more simplified for married same-sex couples. However, many states impose their own transfer taxes, that is gift, estate, and or inheritance taxes. And if you live in or own real property in a state that does not recognize your marriage, transfers to your spouse may be subject to those state-level transfer taxes. So you should work with your attorney and advisors to ensure that your plan incorporates appropriate planning to minimize or eliminate applicable gift, estate, and inheritance taxes, both at the federal level and at the state level. And this does really require a review of your current plan to be certain that the appropriate planning is incorporated. Many people do find it hard to undertake estate planning because it does mean thinking about disability and death, and possibly entails having difficult conversations with your spouse, partner, friends, and family. But the risks of not acting are significant, and I just want to highlight 3 steps that you can take now to get started with the estate planning process. Step 1, be sure to put in place the essential estate planning documents that we briefly discussed today. And if you have those documents in place, be sure to review your current plan with your attorney and advisors to determine if changes are necessary. Step 2, review your beneficiary designations and benefit elections for all retirement plan assets. And step 3, as you work with your attorney and advisors, consider additional estate planning documents that may be necessary to implement your desired estate plan. And I do want to let you know about a few resources that are available to you so that you can learn more about the impact of both the DOMA ruling and proper estate planning. Please visit hrc.org/Supreme Court for up-to-date information on the federal government's implementation of the DOMA ruling. And also on that website are detailed fact sheets that describe how the DOMA ruling impacts a number of important federal benefits, protections, and programs, including fact sheets dedicated solely to federal taxes, Social Security, and private employee-sponsored plans. They really are quite helpful, and I think they'll be very informative for you. You can visit hrc.org/EstatePlanning for comprehensive estate planning resources for the LGBT community and information about ways to create a legacy of equality through a plan gift to HRC in your plans. And I just want to note that plan giving does not have to be complicated. It can be as simple as designating HRC as the beneficiary under your will or as the beneficiary of a retirement account, life insurance policy, or an annuity. And this is just a snapshot of our estate planning website, and we have a feature there that allows you to plan by age. You can see what issues you should be concerned with and what documents you should have in place given your stage in life. And you can also request a free estate planning toolkit that will be sent to you by email. So please do check out the website. I think it will be very helpful. And I also want to mention that we recently completed a new legacy planning publication entitled Writing Your Life Story that can be downloaded at hrc.org/legacy. And we are in the process of finalizing our new step-by-step guide to life and estate planning for the LGBT community, and we expect to release that in the next few months. And I know that will be a great resource for the community, so please keep your eye out open for that. And also Robin and I are both resources for you. So please feel free to reach out to either one of us with any questions you may have about planning for you and your families in this new post-DOMA environment. We would be glad to speak with you. Thank you for joining us today, and we hope we'll speak with you soon.